I talked to Bella already about this happening a lot, so you're not seeing the same. Well, good afternoon. One more Friday talking about ethics in action. Thank you so much for meeting me today at lunchtime to discuss our Article 11. Hey, Mary. So, ethics in action and what we are obligated to do, our responsibilities as realtors. This article is very interesting because it applies to everyday real estate. So, knowing about the code of ethics, what this means to you is knowing that we work as we voluntarily agreed to abide by the code of ethics and based on professionalism and protection of the public. Realtors are subject to disciplinary action and sanctions if they violate the duties imposed by the code of ethics. So today, like I mentioned before, Article 11 of the Code of Ethics states that the services which realtors provide to their clients and customers shall conform to the standards of practice and competence, which are reasonably expected in the specific real estate disciplines in which they engage, specifically residential real estate brokerage, real property management, commercial and industrial real estate brokerage, land brokerage, real estate appraisal, real estate counseling, real estate syndication, real estate auction, and international real estate. Realtors shall not undertake to provide specialized professional services concerning a type of property or service that is outside their field of competence unless they engage the assistance of one who is competent, meaning asking someone for help on such types of property or service, or unless the facts are fully disclosed to the client. Any persons engaged to provide such assistance shall be so identified to the client. So if I use a commercial broker to help me do an evaluation of a property, that person who is the expert that I consulted has to be named. Their contribution has to be made known to the client who's assigned me the job. Okay. So basically, we are required to know what we're doing. We are required to provide expert advice, which people are expecting that we know more than the average person. This applies to the market analysis we do when we go on a listing appointment and we want to do a CMA and determine value. It applies when we're working with a buyer and the buyer says to us, how much would be a fair price that I can go with? What is going on in this market? What price should I offer? It is that type of evaluation, as well as when someone asks for a broker's price opinion, either for a bank or for estate purposes or for insurance purposes. Sometimes we get asked for when it comes to a valuation or an appraisal, if the property is, I sound muffled. I'm going to see if I can get closer. Um, I hope that's better with my sound. So all of the services that we provide have to be provided with definitely a knowledge base that we have available to us. And if it's not something we are knowledgeable about, we are supposed to ask for help from someone who is knowledgeable and then give them credit for that. So standard of practice 11.1 talks about when realtors prepare opinions of real property value or price, they must, first of all, be knowledgeable about the type of property being valued. Also have access to the information and resources, such as having access to the multiple listing service, the tax records, information from the town, in order to be able to provide an accurate opinion and formulate an opinion that is accurate. And also be familiar with the area where the subject property is located. So if I work in a particular area, let's say Bergen County, and somebody says to me, I would like for you to give me an evaluation of a property which is in Mercer County. Definitely that is outside of my expertise. Maybe I have been in Mercer County, I don't even know, but I do not possess enough knowledge about the area to be able to give an informed opinion of value for that property. So the first thing that I'm supposed to do is notify the client, look, I am not familiar with that area. If you insist on me helping you with this particular property, I need to find somebody from the area who is knowledgeable about the area to help me determine what is the value. And that would be the correct way to do it. Okay. And then give them credit. So that I can say, my friend Mary from the Mercer County area, who has been working there for the past 20 years, is helping me in the determining the value of that particular property. Okay. Unless lack of any of these is disclosed to the party requesting the opinion in advance. And that is when we have to really be truthful. And as much as we want a listing or an opportunity to work with someone, you have to provide the accurate information ahead of time. This is a continuation of Standard of Practice 11.1. When an opinion of value or price is prepared, other than in pursuit of a listing or to assist a potential purchaser in formulating a purchase offer, the opinion shall include the following unless the party requesting the opinion requires a specific type of report or different data set. So this is talking about when we do a broker's price opinion, for example, for a bank. They have their own form that we have to use. But if we're doing an evaluation for an estate or a divorce or for insurance purposes or something like that, this information on the bullets has to be included in that report that we provide. The identification of the property, the date that the report was prepared, a defined value or price, limiting conditions, including statements of purpose or intended use. So if it is for an estate, it should be included on there as opposed to loss of use or because the property had a fire or because it's a divorce situation. Any present or contemplated interest, including the possibility of representing the seller, landlord, or buyer tenant. So if there is absolutely any conflict of interest that could possibly exist, it has to be informed in the report, okay? Several years ago, I was contacted by a woman who was getting the house in a divorce. And she wanted for me to give her a broker's price opinion. And the husband, who was going to get some money out of the property by letting her stay there in the property. Basically, it was a negotiation in the divorce, hired an appraiser. I ended up having to go and defend my numbers in court, which was a little bit scary, but in the end, I ended up being the winner because the appraiser, who was a licensed appraiser for the state of New Jersey, was basically chastised by the judge for not informing in the report that he was actually related to the husband, and that his report was not accurate. My numbers were more correct. I did include in there that I had that if the possibility existed of in the future the wife deciding to sell the property, she could, and I would be happy to help her. So these are the kind of things that could potentially get someone in trouble for not disclosing potential or contemplated or present interest. Another thing that's required, the basis for the opinion, including applicable market data. So where did this information come from? If the opinion is not an appraisal, a statement to that effect. Disclosure of whether and when a physical inspection was conducted. So if there was a physical inspection, did the agent drive by the property and do an exterior, just a drive-by at 20 miles an hour in front of the property? Or did the agent actually get out of the car and take a look around the perimeter of the property? Was it only exterior, or was the realtor actually inside of the property and conducted an interior inspection? And then also disclosure of whether the realtor has any conflict of interest, and this was amended in January of 2014. So if we're doing the report for a listing, to get a listing, or if we're doing it just as a not for a listing, but for another purpose, we are allowed to charge a fee for this, for a broker's price opinion. However, we are not allowed to call what we do as realtors an appraisal unless we are licensed or certified as appraisers and we are basically doing the work of an appraiser and using our license as an appraiser. Okay. In the report that we prepare also, we're supposed to also include a statement that says this is not an appraisal and should not be used or considered an appraisal. In Standard of Practice 11.2, Article 11 states that the obligations of the Code of Ethics in respect to real estate disciplines other than appraisal shall be interpreted and applied in accordance with the standards of competence and practice with which clients and the public reasonably require to protect their rights and interests, considering the complexity of the transaction, the availability of expert assistance, and where the realtor is an agent or subagent, the obligations of a fiduciary. This is all talking about making sure that who are we in that transaction or in that relationship? Are we competent enough in that particular type of evaluation? If you are specializing strictly in residential property, you should not be accepting a job to do an evaluation of an industrial property or a gas station or a warehouse, unless, again, this has been disclosed to the client about your lack of knowledge and expertise or about the area, and finding someone who can help you with that. In Standard of Practice 11.3, when realtors provide consultative services to clients which involve advice or counsel for a fee, not a commission. This is where when I was doing the broker's price opinion for the divorce, I charged a fee. We are allowed to charge a fee, but it is not a commission, and it cannot be based on the value of the property. Such advice shall be rendered in an objective manner, and the fee shall not be contingent on the substance of the advice or counsel given. If brokerage or transaction services are to be provided in addition to consultative services, a separate compensation may be paid with prior agreement between the client and the realtor. So if I charge for, let's say, whatever, any dollar amount for doing the broker's price opinion for the divorce that goes together with the divorce agreement and goes to court and it gets approved. But the client says to me, once I get the house, I would like to put it on the market and sell it. That would be a separate agreement, which I am allowed to charge a commission for the sale of the property. But that would be separate. Okay? All compensation, no matter what is the source of it or the reason for it, all compensation has to be paid to the broker for which we work, and then the broker then makes us a check for whatever has been agreed upon. Okay, most companies is a pass through the company, where if we're doing broker price opinions for banks, for divorces, for fire, or for any other reason like that, even though the company gets paid, they basically pass that over to the agent in most cases. Most companies do that, but not all. I cannot guarantee that all do that. Okay, but everything has to be paid through the broker. So it is a company bill that is sent over, not an individual bill from the individual person. Standard of practice 11.4. The competency required by Article 11 relates to services contracted for between realtors and their clients or customers, the duties expressly imposed by the Code of Ethics, and the duties imposed by law or regulation. Again, this has to do with being competent and having our, not only following the Code of Ethics, but also what we are required to do as realtors and licensees in the state where we operate. All of the commissions or fees are negotiated and discussed between the realtor and the client, but again, we as realtors are working on behalf of our company. Now let's go on to case interpretations. Case interpretations 11.1 to 11.4 have to do with appraisals and appraisers. These are people who have a separate license than what we have as real estate agents. Excuse me. These are specifically for those appraisers. And I'm just going to mention some of them because most of our agents are not appraisers. But there have been a few case studies in which the appraiser did not provide knowledgeable and informed opinions because they were not knowledgeable about the area or the type of property. And there were a couple of them in which the appraiser, knowing that they did not know enough about the property or the area, contracted with one of them an engineer and the other one asked other agents who were familiar with that information, but did not make a note, did not give the proper credit to the sources that were used for the appraisal reports. And for that reason, those appraisers who also happen to be realtor members got in trouble with an ethics complaint. Case interpretation 1110 has to do with the realtor's obligation to disclose interest. This one I am going to go more into because it applies directly to us as real estate agents. A client who is the owner needed to sell a property. She approached the realtor to list the property. They agreed to the terms of the listing and the property was listed. An offer was made and was accepted by the client. After a prospective purchaser completed the loan application, the realtor was contacted to appraise the property. When the lender was preparing the closing statement, the lender became aware that the listing broker was also the same person who did the appraisal and filed a complaint with the Board of Realtors alleging that the realtor had failed to disclose in the appraisal report that he had an interest in the property, specifically seeing that the sale closed. The complaint was referred to the grievance committee for hearing and a panel of the association. At the hearing, the realtor protested that the lender was misreading Article 11 as interpreted by Standard of Practice 11.1, claiming that disclosure of whether the realtor has any conflicts of interest referred only to an ownership interest. The realtor concluded that the listing commission had been earned when a ready, willing, and able purchaser contracted to purchase the property, and that the appraisal process was separate and distinct from the brokerage process. The hearing panel concluded that the realtor's defense was not accurate because he was the listing agent and he had a bias in favor of the client, the listing agent, the seller, since a successful transaction would benefit the realtor in the form of a commission. This realtor was found in violation of Article 11. Okay, so not disclosing and actually accepting an opportunity to do a job like that is definitely a conflict of interest. The next case interpretation has to do with the realtor's obligation to disclose present or contemplated interest. The owner was considering refinancing a property, and client be a lender. A lender ordered an appraisal from a realtor. The appraisal report was completed, and later the owner decided to sell the property instead of refinancing it. The owner then contacted the realtor who had done the appraisal. This realtor listed the property and an offer was made that was accepted by the owner. At the loan application, the prospective purchaser told the lender, who was the same lender that was going to be doing the refinancing originally of the landlord, of the seller, that a recent appraisal on the property had been done for the client. When the lender became aware that the listing broker was also the appraiser, the lender filed a complaint with the association alleging that the realtor had not disclosed her present or contemplated interest in the property as required by Article 11. The complaint was referred to the grievance committee, which then went to a hearing. A written statement from the owner, the seller of the property, containing all the facts above, was entered into evidence. The realtor stated that the appraisal had been completed in accordance with Standards of Practice 11.1. And it was only after the owner had decided to sell the property rather than refinance that there were any discussions about the realtor representing the owner in the sale of the property. The realtor stated that the owner had been appreciative of the time that she has spent discussing the subject's neighborhood, existing market conditions, and that the owner had decided that he wanted someone really knowledgeable to represent him in the sale of his property. Because the realtor's disclosures regarding present and contemplated interest were true at the time they were made in connection with the appraisal, the hearing panel concluded that the realtor was not in violation of Article 11. So two very similar situations. It all comes down to disclosure. And what was the time frame? And what was the interest? So in these two case studies, we see that two very similar cases could end up having totally different outcomes. Again, disclosure, disclosure, disclosure. Whenever in doubt, disclose. So it's not enough to know, it's more important to practice what we know. I appreciate your time with me today, and I hope you have a fabulous weekend. Have a great day, and I will see you next week. Same day, same time. Bye.